Hi, I'm Ken Gottlieb. I'm the administrative judge for the 17th Circuit County Court, and I'm here with Debbie Carpenter-Toye. She's our judge in the county court who is chair of the criminal division.
How
And
you doing there, Judge Gottlieb?
great, how are you?
Good today.
So, people get a notice in the mail that they have to appear for an arraignment. What should they do?
So you get that notice in the mail, and it has your name on it. It has the judge's name on it. It has the courtroom that you're supposed to go to. It'll have the address of the courthouse that you're supposed to go to, and you need to appear. And the judge will give you some instructions when you show up for that arraignment date.
And if they don't show up, what happens then?
Well, when you don't show up for an arraignment date, or any court date for that matter, the judge has no choice but to issue what's called a capias, or a warrant, for your failure to appear. So you need to really pay attention if you get that notice in the mail. And if you think that your address might not be correct, you need to really follow up and try to make sure with the clerk of court that they have your correct address.
Yeah, so it sounds like the most important thing is you have to show up. So when you get that notice in the mail, what's the judge going to do?
So you're going to come into the courtroom, you're going to have a seat. Some courtrooms ask you to check in with the court deputy, the bailiff that's assigned, some don't. Just take a seat. The judge will come in, and the judge will then explain to you a number of things, starting out with what the charge is that you're there for, what the possible maximum penalty is for that charge, probably advise you of your rights in terms of your ability to either hire a lawyer or to apply for an appointed lawyer, and tell you how they're going to proceed that day with the actual arraignment.
And once they tell you what the charge is, they're going to try and give you an opportunity to make a plea. What's that mean?
So in some instances, when you appear for an arraignment, you may want to resolve the case or end it that day with a plea. And if you want to do that, most likely the judge will defer and ask the assistant state attorney in the courtroom what their recommendation might be for a sentence if you wanted to enter a plea of either guilty or no contest that day to the charge.
And they can also plead not guilty, right?
And they certainly can plead not guilty, and if they do plead not guilty, that will be entered on that day, and they will have another date to come back to court where they will be entitled to have a hearing or a trial to determine how the case is going to proceed.
And if they plead not guilty, they get to keep all their constitutional rights. But if they plead guilty, they're waiving all their constitutional rights.
Right, and in our courtrooms here in the 17th Judicial Circuit, if you come in and you'd like to waive your right to a trial and waive your right to have the state prove the charge against you, you could enter a plea on that day, and you could enter a plea of either guilty or no contest. Usually before you do that, you would need to read and sign a plea form that we have in the courtrooms, which go through your rights as to each of the charges that you're facing.
And if they plead not guilty, they get a trial. So what's the difference between a jury trial and a non-jury trial?
So if it's a non-jury trial, if you decide you want to have a non-jury trial, and the state agrees to that, which they often do, you would be entitled to have a trial where the judge assigned to your case would listen to the evidence presented by the state attorney to determine whether or not they proved the case against you beyond a reasonable doubt. And if they did, the judge would be the person who finds you guilty and would sentence you. If they didn't or were unable to prove the charges against you, then the judge would find you not guilty and you'd be free to go.
And a jury trial is the same, except that there's 6 members of the general public who come and become jurors.
Yes, and so if you decide you want to have a jury trial, then the jury has to be selected, and those jurors are selected randomly from people who are called to jury service here every week to listen to cases such as yours.
And so the judge tells you what the charge is, and you tell him what the plea is. But what's the difference between a first-degree misdemeanor and a second-degree misdemeanor?
So if you're charged with a first-degree misdemeanor, the judge will tell you, you are charged with a first-degree misdemeanor, and it is punishable by up to 1 year in the Broward County Jail. And if you are charged with a second-degree misdemeanor, the judge will tell you that as well, and you would be facing up to 60 days in the Broward County Jail.
And the difference in fines?
And there are differences in fines depending on the type of charge and depending on what the state might recommend. You would be fined and or have to pay court costs as well. Most times the judges will give you some time to pay those court costs and fines if you decide you want to enter a plea.
So one of the biggest things is your right to a lawyer. What can you explain all that?
Sure. So when you come into the courtroom and you're advised of what the charge is, the judge is going to most likely tell you whether or not you're entitled to be represented by a court-appointed lawyer. In some cases, you might not be eligible for a court-appointed lawyer, but in every single case, you are entitled to be represented by a lawyer. So you might have to go consult with a private attorney if you're not eligible for a court-appointed lawyer.
Yeah, sometimes people say, hey, this is just a misdemeanor and I don't need a lawyer because this case should be dismissed. But they have to file a motion to dismiss. It just doesn't magically disappear. Does that happen to you?
Right, it happens all the time. People come in and say, well, I have an explanation. And what I usually tell people is, when I call your name in an arraignment and I ask you to come forward, I'm going to tell you the charge. I'm going to talk to you about whether you'd like to hire a lawyer or have an appointed lawyer, and whether or not you'd like to enter a plea. I also tell you, today's not the day to tell me about the facts of your case because everything's being recorded in the courtroom and you might say something that would be used against you at a later time.
Yes. So for many of the cases, we have diversion programs. So that's pretty interesting. And
yeah, so the prosecutor, as I said, when you come forward and the judge asks the prosecutor what the recommendation would be, might say, this person is eligible for diversion. On DUI cases, we have a diversion program. On people that are veterans who have served honorably in our armed services, there's a veterans court. There's also a misdemeanor diversion program in certain cases that you might be eligible for. And if the prosecutor recommends that you're eligible for that and you elect to do that, the benefit of that is that when you successfully complete that diversion program, the charges are dismissed by the state attorney.
Or the charge might be reduced.
The charge might be reduced in some instances, like the DUI diversion. Yes.
Yeah. And one of the issues that comes up in the plea form is immigration.
Right.
So when a person is not a citizen, what happens?
So if you are not a United States citizen, you should consult with an attorney prior to entering a plea to a criminal charge. And people often say, well, it's just a misdemeanor, I'd like to resolve it today. And I tell them, I would accept your plea, but I want you to know that there are consequences that you might face as a result of entering a plea, and you really should consult with an attorney before you make that decision.
And if you resolve a driving with your license suspended, can it also lead to further actions on that as well?
Clearly, the law in Florida is that driving on suspended license charges are cumulative. That is, the Department of Motor Vehicles keeps track of them. And because of that, if in fact you have previously entered a plea to a driving on a suspended, you come into a courtroom and enter another plea, it could result in your driver's license being suspended for up to 5 years as a habitual traffic offender.
Yes, so that seems to be everything that might happen at an arraignment in a nutshell. Is there anything else you would like to say?
No, I just think people who come into the courtroom should recognize that they're there for a criminal charge. There are consequences, and they should really think about how they'd like to proceed with their case and decide that at the arraignment.
Okay, thank you so much for being here, and have a wonderful day.
You too. Thank you very much.
Good luck.